My name is Josh Lawler. I am a partner at the law firm of Zuber, Lawler & Del Duca, where I head our firm's new technology group. I've been practicing securities laws for almost 25 years, and I'm extremely focused on distributed ledger technology and the regulation that goes therewith. Today we're going to talk about the Token Taxonomy Act of 2019 and why it is so important that this actually passed through Congress. So, this is not legal advice, this is not investment advice. That part's very, very important. The SEC recently released over 200 pages and over 138 questions to the securities community in an attempt to get advice on harmonizing the various securities issuance exemptions. And while that's really a wonderful thing, and certainly I'm planning on responding to it, as I look at it, I think the issue is not harmonizing the exemptions, but recognizing that a lot of digital assets just shouldn't be securities. So let's start with this. If you look down under at Australia, Australia has a very, very interesting regulatory structure. It's very simple. They take a look at your digital asset and they break it down into one of two things. Either it's a financial product, that's your stocks, your debt, your interest in real estate, your investment contract is a nod to the Howey test. It might be an investment in Orange Grove production. And then you've got not financial products. Not financial products are kind of everything else. And the financial products are under regulation of their securities administrative body. And the not financial products are under regulation of their consumer protection body. That makes a lot of sense because the not financial products really do end up being something like goods and services, consumer protection. Okay, so that Token Taxonomy Act of 2019 was introduced in the House. It's currently with the House Financial Services Committee. And it's also very simple. It's a short bill. What it does basically is it breaks digital assets, again, into financial products and not financial products. And there's a long definition of a token for not a financial product. And it then says that the definition of security does not include digital tokens. And then it applies that to the Securities Act of 1933, the Securities and Exchange Act of 1934, the Investment Companies Act of 1940, and the Investment Advisor Act of 1940. But it's not done. It also says something very, very important, and it was a reintroduced bill just to get this piece in, and that is that it does not change the jurisdiction or powers of the Commodity Future Trade Commission or the Federal Trade Commission, so the CFTC and FTC. And those organizations are respectively responsible for governing commodities trading and, among other things, consumer protection and fair marketplaces. So wonderful. How does that all work? How does that break down? Well, let's take a few tokens, different tokens of different characteristics, and apply, and we'll see. So, the first one I want to take is just Bitcoin. Bitcoin is not a security. It's been said so by the SEC. It probably is a commodity, and it is traded as a commodity. There are futures, and that is under the jurisdiction of the CFTC, as well it should be. And this makes sense. Bitcoin doesn't have an issuer. There's nobody to do any kind of financial reporting. Even the people holding it now generally refer to it as digital gold, and digital gold being gold, well, gold is a commodity, and that makes all kinds of sense. So now let's talk about something a little bit further towards what you might think of as a security. And that's a token called Ravencoin. Now, Ravencoin is a token that is based off of the Bitcoin blockchain. It's mined, it's a proof of work. And what Ravencoin actually is, it is a methodology for the creation of assets that can be traded on a peer-to-peer basis. And an asset could be anything. An asset could be a particular bottle of wine. An asset could be a right to have a person come and paint a mural on your kid's wall, or an asset could be a share of stock. Any of those could ride on top of the Ravencoin system. The Ravencoin itself, however, never sold in any kind of an offering. The only way Ravencoin gets into the world is it's mined, very much the way Bitcoin is mined. So where does that fall on the spectrum? Where should it be regulated? Well, it's not ever been issued in a securities offering. I think it's outside of what the SEC would do. It is traded on exchanges, and from that perspective, it is possible that somebody could conceivably do some type of fraudulent exchange, and it's possible that you could at some point have brokers who are brokering sales of Ravencoin, even though that doesn't exist yet. It seems like the CFTC is the right place for this to go, in part because it's not a security, and in part because from an FTC perspective, it's not really a good or service. It's kind of this other thing that's used, kind of like a commodity. Now, it's important to note that the things on top of the Raven coin, those assets, they might be securities or commodities or goods or services themselves, and that's a whole different discussion. But if you put your share of stock on top of the Raven coin system, now it's a security and the SEC shouldn't be involved. Okay, next token. I want to talk about ChainLink. ChainLink is a very exciting project, and what ChainLink is basically is smart contract middleware. So you've heard about smart contracts. They're self-executing contracts. Something happens in the world and your contract executes automatically. Okay, well, something has to tie the blockchain where that smart contract is sitting to the real world event that triggered the execution. Enter ChainLink. And ChainLink will design those types of APIs. And now ChainLink's system functions on the link token. And the link token is there for really two purposes. One is because they have what they call oracles. You can think of them as transaction validators. And those oracles need to have a reason to perform their services. And the reason is because they're getting paid in link tokens. Also, those oracles, in performing those services, have to stake a certain amount of link tokens, which are then removed, or they're penalized, or the tokens are no longer theirs if they violate certain rules. Uptime, for instance, they need to be ready to verify these smart contracts. That's it. There's no consumer use for the link token. However, in order for this to all function, those validators, they need to be able to take those link tokens and they need to be able to monetize them. Otherwise, what's the point? I can't pay my taxes in link tokens. I can't buy a loaf of bread in link tokens. So I got to be able to monetize my link tokens. And there's only one place I can do that. That's on an exchange. Okay, so it's on the exchange. Ravencoin's on the exchange. Bitcoin's on the exchange. Not definitive, but ChainLink did an ICO. They sold 350 million tokens out of a total of $1 billion. They raised $32 million, primarily from large investors, but not entirely. And that was done, before the SEC came out with, applying the Howey test to the DAO transaction or anything of that nature. But it was definitely an ICO. It was definitely a sale of link tokens with the expectation that those were going to increase in value based on supply and demand economics. Now, that is what the SEC is currently calling a security. That's the current test. And if the SEC were to look at this link ICO, they would probably find that it was, in fact, an unregistered public offering. Okay, well, that's not good, but it gets worse. The only way for link to function is if it can be liquid and traded on exchanges. Well, now the link token is supposedly a, quote, security. That means that there are reporting requirements. So now ChainLink, the organization, is now going to be responsible for putting out financial statements and all of that type of stuff pursuant to the 34 Act. Now, are those financial statements actually useful in terms of evaluating link? Well, not the way they're currently composed. That's a story for another time. The last one I'm going to bring up to mind is the KIN token, which the Kik project put out. And there's been a lot of attention focused on this because the SEC just filed a complaint against Kik for their unregistered public offering that they did in their ICO. Now, the KIN token serves no purpose other than being a medium of exchange in the Kik Messenger application. And the only thing that you can buy with it is an emoji. Originally, it was an emoji of a honey badger. They may have added a couple more, but this is clearly not nearly the same thing as Bitcoin or Ravencoin or Link, which all have kind of bigger pieces. So, there's this ICO, and the SEC's got their complaint. Is it right that the SEC is doing that? And I have to say, no, it's not right. It's not right because regardless of the Howey test, if you lump the KIN token into the classification of security, then you've got to take all of these digital assets that are really just consumptive use tokens and put them there also. But here's the thing. It's not like there's no enforcement against Kik. The CFTC has the same anti-fraud enforcement powers that the SEC does. The FTC has the same anti-fraud enforcement powers that the SEC does. Either one of them would be more appropriate. And in fact, the CFTC has done some enforcement against ICOs, and the FTC has done some enforcement against schemes using digital assets. So they're already right there. Now, you might say, okay, well, great, but if these aren't, quote, securities, then what about the ongoing reporting? How do I know that if I'm purchasing off of an exchange like a Binance, that I have all the same information that somebody who's an insider in the organization might have? Well, the answer is you don't necessarily, which is also the same for most commodities. In fact, you don't necessarily have as much information on the gold marketplace as you might if you owned a mine. But that said, there is another option, and it's an option that I like a lot, and that's the self-regulatory organization. So for anybody who wants to have an idea of what that might look like, there's a great organization called Messari. You can find it at messari.io. And it's sort of an open source information area that reports on all the various tokens and their circulation and their transparency and their governance and any number of other things that, quite honestly, are a heck of a lot more relevant than what's required in the Exchange Act for a reporting company. So, with all that said, big proponent of the Token Taxonomy Act of 2019. I have extremely high hopes for it. And for anybody who is watching, I hope that you will do whatever you can to support that as well. I would love to hear from you. Comments are welcome. I'd love to continue the discussion. Again, my name is Josh Lawler. I'm at the law firm Zuber, Lawler, and Del Duca. And I hope that was informative and helpful.